Welcome to Anchored in Law, the unembedded take on law. We are in conversation with Justice Madlanga of the Constitutional Court of the Republic of South Africa. Thank you, Justice, for talking to us at Anchored in Law.
Thank you.
Briefing patterns, which we have been talking about for many years. You would know you were in practice for quite a while. Since joining the Constitutional Court some years back, in your experience, has there been any change in the race and gender makeup of counsel or legal practitioners appearing in the Constitutional Court?
I don't think there's been much of a change. All that one can say is that within the junior ranks, in the sense of being led, one does see a representation of women and black legal practitioners or advocates. But in the senior ranks, one continues to see the same faces. If I'm talking black advocates, for example, one sees, same people. I mean, you've appeared before us a good few times. Hamilton Maneche has done so. Tembeka and one can easily count, the sort of people who have appeared here.
I know it
quite easily if one stretch
yes.
and it's worse with it's worse with women. I mean, yes, we've had Tandy Norman, we've had
Gossi Thomas,
and we've had the Silk from Pretoria. What's her name? But if I scratch my head hard enough, could easily count all of them. All of them. It's a trickle. It's literally a trickle, and I don't think I could say that if there has been an improvement, it has barely been perceptible.
To what would you attribute this? I know it may be outside your sphere of knowledge or influence, but could you hazard a guess? You've been a practitioner before.
It's easy and difficult to answer. Easy in the sense that it's the same battles that even I, as part of Advocates for Transformation, and even as part of Nadel, we used to fight, about briefing patterns. Those continue to leave. And same old story.
Yes.
Same old story.
And I know it's not a job of the Constitutional Court or a Constitutional Court judge, but let me give you an example. The Judge President of the Gauteng High Court had started something where he required practitioners to fill in a form when they appear in matters for setting up, so that for set down, so that one says the nature of the matter, something akin to a practice note, the nature of the matter, the name of the counsel, the race of the counsel, the gender of the counsel, and so on, so that you can keep statistics of the briefing patterns. And I understand there had been some reluctance from either practitioners or their briefing attorneys and so on. But is there something similar that the Constitutional Court could introduce just to keep track, so that we don't thumbsuck and say, well, nothing has changed, but we can actually produce the numbers and say from what year, maybe in the Chief Justice's annual report, that there is a section there that sets out how many black counsel have appeared and actually argued cases, how many black counsel have appeared, led, how many women counsel have appeared, so on. Is that not sort of like naming and shaming? Because you would also say who the instructing attorneys were and who the client was.
It's not anything we as a court or a collective have applied our mind to. And I guess, maybe if we were to be so minded, it would be something that we will have to sit down and think about.
Yes, I think I may have raised it with the Chief Justice.
Yeah. That's the place to raise it.
Yes, I think I'm going to follow up on that. Now,
I hope I'm not putting the Chief Justice.
no. It's my initiative. No, thank you, Justice Madlanga. The Constitutional Court being the apex court. Now, once the apex court has made a decision, I mean, there's no appealing it and there's no reviewing it, although there is a provision in the rules, Rule 29, where you can bring an application for a rescission or an amendment or variation and so on. Has that ever happened?
We have had applications for reconsideration, but
Yeah.
As far as I'm aware, I think since I joined the court, all of those have failed.
Have failed?
Yeah.
Why is that? Were there no prospects?
I guess all of them were not meritorious.
Because I must tell you, I thought of one at some stage, but eventually decided against it.
I think also outside of your Rule 42, because we incorporate
42 in 29, yeah.
Yes. Outside of what's itemized in that rule as bases for reconsidering, even though we have the power to, outside of those, I guess it would be a power source in Section 173 of the Constitution.
Yes.
The court has held that it would be in very exceptional circumstances where it would do that. Interest of justice,
yes.
But interest of justice where the circumstances are quite exceptional. That's the test that the court has said. But as I say, I'm not aware that it has ever applied it and reconsidered and set aside its own decision.
Yes. Well, a cynic could be forgiven for saying, well, the Constitutional Court doesn't want to set a precedent that it can actually commit a mistake. And so it will never find an exceptional case where it would vary or reconsider its own judgment. Would that be a fair comment?
I would say perhaps it would be taking it too far to say it would never, I mean, it's that the rule is there, that the principle is there. One would imagine that in a deserving case, the court could.
Yes. Okay, given the state, whatever it is, I'm not making any judgment of the legal profession currently, is there anything about the manner in which counsel conducts him or herself, or legal practitioners generally conduct themselves, that keeps you up at night?
Not really.
No.
I'm quite happy with how counsel conduct themselves.
Well, lately there has been.
Yeah.
Lately,
there will be, I mean, the odd occasion when there will be, human beings being what they are. There's just a little annoyance there. I remember one matter, for example, where counsel made a remark. We took the tea adjournment, and when we came back, the Chief Justice lambasted him, But those are very rare. I mean, by and large, counsel conduct themselves.
yes. Now, recently in a case, well, I mean, I'm not going to get into the merits of it, but in a case in Pietermaritzburg, which was an application for leave to appeal, counsel was criticized by the full bench there. The client was criticized for what was contained in the application for leave to appeal. And as a result of that, the full bench there says it mulcted the client in costs. Now, how do I phrase the question? Is that a fair reflection of a judge taking umbrage to what, or expressing his displeasure, as they say, for what the legal representative did, rightly or wrong, whether the court is right or wrong in this instance, but to take it out on the client? and mulcting the client in costs in circumstances like that?
In your experience and mine, we have seen matters where courts will draw a distinction and actually hit not the client but the practitioner for costs out of her or his pocket, the so-called day bonus order. So I guess in the instances where it will be the client that's at the receiving end, perhaps it's instances that are not clear-cut and where the court cannot say it's out and out the practitioner that's to blame.
Or in my
this is just an assumption on my part, but the point I'm making is that the court is quite alive to what I guess is the fundament of your question.
Yes.
Which is, in certain instances, shouldn't a line be drawn? The courts have drawn that line sometimes.
Yes, and in my experience, a court would rather say counsel must report him or herself to his or her bar counsel and then have the bar counsel deal with the issue. Right, finally, the courts. Is there anything about the way in which the courts operate that concerns you?
The one big problem perhaps is when a litigant comes to court, they want results and they want results immediately. You and I know how long the litigation process takes. Sometimes it takes years and years. And in practical terms, sometimes by the time the outcome comes, it may have become totally irrelevant to the life of the individual. They may not have withdrawn the application, so that the court is not even in a position to say this has become moot. But from where the litigant is saying this may have become totally irrelevant. So to that extent, yes, there's something quite problematic. And unfortunately, it's a structural problem which needs some serious consideration, serious looking into, and it's not as if the judiciary is not aware of the problems. And it's something that the Chief Justice did touch on in his accountability report of this year. Maybe he did the previous year as well.
Yes. But what would it take, I mean, to shorten the lifespan? I know in the Constitutional Court, I think the standard for reserve judgment is something like 4 months. Give or take. Although there have been judgments outstanding for up to 8 months. But I understand.
And sometimes even longer. I remember one that was heard when Justice Chapter and I were on leave late, in the second half of last year. It was still doing the rounds and not yet handed out. When we came back, and it stretched on for a bit of time, even after we had come. So there are those sometimes, but those are exceptions.
Yes, I know I said finally, but finally, what do you do to relax, Justice Madlanga, to let your steam off?
It's mainly watching TV, but I do that normally outside of term. During term, it's very hard to do that. But then on the odd occasion, it will be going out for dinner with the family. And then also I like to watch movies with my 6-year-old son. So I watch cartoons, and I've come to love them. And
Do you watch the news on television?
Oh yeah, news yes.
You read newspapers?
I do, but newspapers, I can't keep up with reading newspapers every day. I read Sunday newspapers only. If that's lazy, then I'm lazy. I read Sunday newspaper. I listen to the radio all the time, so I get my news there. I watch news on TV as well.
Yes.
Then what I also do, but only in December, is also to do a bit of reading. Not much. And there I like reading mostly biographies. Like one of the holidays I read Butekhan Musanikes, I read Edwin Cameron's, and now I'm going to read one of my homeboys is somewhere here. Mr. Fezile Dantile, I'll read that
Yes.
this December. So, but only in December. Again, maybe I'm lazy, but I just cannot do that.
You said you watch the news and from time to time you read newspapers.
No, weekend newspapers.
Weekend newspapers. You also said judges are human beings. So I take it that judges are susceptible to being influenced by the newspapers that they read and the news bulletins that they watch on television?
Not this judge, and I want to believe not other judges as well.
You want to believe?
At least judges where they are sought, I don't think they are.
So how do we find out?
I'll be quite surprised to hear that they are.
Who are influenced by what they read?
By what they read.
I would have thought you read something in order to learn something from it. And so you process and somehow you influence one way or the other.
Not, I thought what you mean is, will I read a newspaper and hear that there's testimony by X given to a journalist that proves
No,
B,
not.
and then do I get influenced by that? So,
No. Not in that sense.
Never.
The sense I mean is we are the sum total of what we know and don't know. So we can't ignore what we know, whether it's a fact or an allegation. It lingers somewhere at the back of our minds, unconsciously or subconsciously. When we make a decision, we may not be aware that that is a factor until we interrogate it honestly. And then we realize, I may have been influenced by that. That's all I'm asking. Isn't there a possibility of that happening?
I don't think with me, because I'm always quite alive to what I have read in the newspapers. And I always consciously tell myself that I will not allow myself to be influenced by that. It must first be contained in the papers that are before me for it to be a factor at all in my decision making. And I must say that in this court, I believe that is the position with my fellow judges as well. There are occasions when one colleague will say, no, where is that here? Yes, it's out there in the media, but it's nowhere in the papers. That should never. So I believe that we are not influenced by it.
There is a judgment of a full bench that seems to have taken judicial notice of an election, what do you call it, an election trope, for lack of a better term, New Dawn. The opening sentence is, the New Dawn has left very little untouched, something to that effect. And then it goes on to make a judgment that aligns, that can be read to aligning itself with the New Dawn campaign. That's why I'm raising this. But we'll see. Maybe that judgment is on appeal, maybe it's not, and we'll see what the appeal court has to say about it. Yeah. Justice.
And also, but then you say, there's the judgment appears to be aligned with it, because sometimes you will have the openers, but they do not necessarily influence what you.
Yeah, no, that's possible. But why open that possible
basis for criticism?
Yes.
Yeah.
Justice Madlanga, thank you very much. It's been an absolute pleasure and honor to talk to you.
Thank you very much, Advocate Ngabana. Thank you.
Thank you, Justice.